Good morning. I welcome everyone to the 32nd meeting of the Justice Committee in 2012. Can I ask everyone to switch off mobile phones and other electronic devices completely as interfere with the broadcasting system, even when they're switched to silent. Apologies have been received from Alison McInnes and David McCletchy, and I welcome Margaret Mitchell, who's substituting for David today. Item 1, the committee is invited to agree whether to consider item 3 in private. Is the committee agreed? Agreed. Thank you. Now, I must say to you that we have to get to this item today, so I intend to just take evidence from the Cabinet Secretary at 11:15, as we must sign off the budget, our report on the budget. Right, so you've been told. Item 2, we're back to the Scottish Civil Justice Council Criminal Legal Aid Assistance Bill. This is stage 2 proceedings on that bill, and I welcome the Cabinet Secretary for Justice and his officials. Members should have copies of the bill, the marshalled list and groupings of amendments for today's consideration. Now, I'm going to move straight on, so I hope you're all ready. I'm going to take it at a reasonable pace for some of the very elderly members of this committee who said I accelerate too much, naming no names, Mr Campbell. The question is that Section 1 be agreed to. Are we all agreed? Agreed. Agreed. I call Amendment 25, this is in the role of the Council, in the name of Jenny Mara, grouped with Amendments 26, 28, 29 and 30. Jenny, please to move Amendment 25 and speak to the other amendments in the group.
Thank you, Convener. Amendment 25 would give the Council a duty to advise the Scottish Government on civil justice matters and a duty to consider how to make the civil justice system more accessible, fair and efficient. The bill currently provides the Council with a duty to advise the Lord President on changes to the civil justice system and not the Scottish Government, and there is currently no duty for the Council to consider how to make the civil justice system more accessible, fair and efficient. To afford the Council a similar duty to advise the Scottish Government on civil justice matters as it does the Lord President, I believe is the right way to ensure that civil justice policy remains the preserve of our democratically elected Parliament and Government. Constitutionally, it is for Government to make policy and for Parliament and this Justice Committee to scrutinise it. And although I was reassured that the Lord President's interpretation of the bill as it currently stands, that reference to policy was in relation to policy of rules of court. I do believe that the bill should be beyond interpretation, and putting this provision into the bill will allow Government to continue to execute its obligation over civil justice policy in its wider definition, should this be something the Council takes upon itself to consider. The Cabinet Secretary and the Lord President have both concluded that the Council will be tasked with implementing the Lord President's recommendations of the Gill Review. These are wide-ranging and touch upon a number of areas of civil justice policy. For that reason, both the obligation to advise the Government on these changes and the obligation to consider how these reforms will make our civil justice system fairer, more accessible and efficient are, I believe, important provisions. I move the amendment in my name.
Okay. Any other members wish to speak? No. Cabinet Secretary.
I will discuss Amendment 25 and its consequential Amendments 26 and 29 first. I appreciate Jenny Mara seeking to ensure clarity within the bill as to where the responsibility for justice policy properly lies. However, I do not agree that the bill is unclear in this respect, and I hope I can provide some reassurances on what I do agree is an important constitutional issue. The Council is essentially an advisory body. It must advise the Lord President on improvements to the civil justice system, and it must assist the Lord President in the Court of Session in preparing rules of court. The Council's duties to advise the Lord President should be understood within the context of the Lord President's statutory functions under the Judiciary and Courts Scotland Act 2008 for making and maintaining arrangements for securing the efficient disposal of business in the Scottish courts. It is in this context that the Council's duties to advise the Lord President should be viewed. The Council's advisory functions are intended to assist the Lord President in fulfilling his duties under the 2008 Act. The bill makes it clear that the Council may advise ministers. I see no need to compel it to do so. Ministers in Parliament can take the Council's advice into account if we so wish. The Lord President discussed these issues when he appeared before this committee to discuss the bill, and I understand the committee was largely reassured by his evidence. Comparisons have been drawn with the Civil Justice Council in England and Wales. That body is an NDPB under ministerial direction. I believe it appropriate that responsibility for the Scottish Council, which will differ in several ways from the Civil Justice Council in England and Wales, rests with the Lord President. The Government will remain the body responsible and responsible to Parliament for the development of wider justice policy. Nothing in this bill will affect the capacity of the Executive, the Legislature and the Judiciary to continue to make those decisions which appropriately rest with them. I am unsure whether the amendment achieves the clarity desired. I would submit the proposed dual function might even blur the lines, as it suggests that the Council must consider matters that properly sit with ministers. With regard to the proposal to place a duty on the Council to consider how to make the civil justice system more fair, accessible and efficient, the bill as drafted provides at section 2, subsection 3, that the Council does not have to merely consider this issue, but rather that for all its functions, which encompass the whole civil justice system, it must have regard to the principle that the civil justice system should be fair, accessible and efficient. I believe this is a stronger protection which will permeate as a guiding principle for all the functions of the Council. Amendment 28 adds the ability to make proposals for research to the Council's powers, and although I consider there's little doubt that the Council would be able to do so under the bill as drafted, I am happy for the bill to highlight that. Amendment 30 inserts a reference to the sections under which the Council may make recommendations. Section 32G already provides that the Council may publish any recommendation it makes. I believe Amendment 30 is therefore unnecessary. I therefore invite the committee to reject Jenny Mara's amendments, with the exception of Amendment 28, which I am pleased to support.
Jenny, wind up, please.
I would still like to, I think I've said what I want to say on the amendments, Convener, but I'd still like to move amendment.
Oh, you've moved, you're pressing it?
Yes.
That's fine, thank you. The question is that Amendment 25 be agreed to. Are we all agreed?
Yes.
There's a division. Those in favour, please show. Those against, please show. There are no abstentions. That's 3 for, 5 against. That amendment is not agreed to. Call Amendment 26 in the name of Jenny Mara, already debated Amendment 25. Jenny, to move or not move?
Since Amendment 25 has been defeated, Convener, I'll not move Amendment 26.
Thank you very much. The question is that Amendment 26 be agreed to. I beg your pardon, it's not moved. Call Amendment 27 in the name of Jenny Mara, grouped with Amendments 1, 2, 3, 4 and 11. Jenny, please to move Amendment 27 and speak to all the other amendments in the group, if you wish.
Thank you, Convener. Amendment 27 will give the Council an obligation to consult on changes to rules of court. Due to the complexity of many rules of court, organisations have frequently raised concerns that court users do not have an adequate understanding of the rules. Organisations like Women's Aid have said that the opportunity to engage with the Council on proposed changes would improve the service they provide by ensuring they are informed and engaged in the decision-making process. I believe it would benefit the Council too. To afford them the ability to consult on rule changes would ensure that they are making decisions with the benefit of the views of all interested organisations. And I move Amendment 27.
Thank you very much. Call Cabinet Secretary to speak to Amendment 1 and other amendments in the group, if you wish, Cabinet Secretary.
With regard to Jenny Mara's Amendment 27, which would require the Council to consult such persons as it considers appropriate before preparing draft rules, I would point out that the Bill gives the Council flexibility in this regard. Under Section 3, the Council will have powers to consult on any issue within its remit. As I've mentioned on previous occasions, the expectation is that much of this Council's work will be carried out at committee level, where there will be ample opportunity for individuals and organisations to contribute. The Civil Procedure Rule Committee in England and Wales, which drafts rules and has no policy function, is required to consult such persons as they consider appropriate and meet, unless it is inexpedient to do so, before making or amending rules under Section 26 of the Civil Procedure Act 1997. The Scottish Council, which will have the power to consult on any matter within its remit, will have much broader functions in the Rule Committee, and as such it will necessarily operate in a more inclusive manner. I do not think, therefore, that a statutory duty to consult is needed. I do appreciate Jenny Mara's concerns and the concerns of some stakeholders that the Council might operate as a closed shop. However, I do not believe that that will happen, and indeed I do not believe the Bill, which opens up the current arrangement significantly, would allow it. The estimated costs of the Council provided in the financial memorandum to the Bill include costs associated with public consultation. up to £10,000 per year and significantly more during civil courts reform, potentially up to £50,000 at its busiest period. Those figures were developed in collaboration with the Lord President's office, and I hope the committee will take that as a good sign the Council will indeed consult. And although the existing councils do carry out consultations, such as it did for the new rules in the inner house of the Court of Session, where consultation extended to the holding of a public meeting, I consider it would be disproportionate and undesirable to require the Council to consult prior to preparing every set of rules. In many cases, rules will be taking forward technical changes purely to give effect to primary or subordinate legislation, the subject matter of which may have already been subject to extensive consultation and which in any case will have been considered by Parliament. I believe the broad power to consult to be sufficient and do not therefore consider it necessary to place upon it the statutory duty contained in Amendment 27. Turning to Amendments 1 to 4 and 11 in my name, these amendments have been identified as necessary to ensure that should proposals for any new court be brought forward, the Council would be able to consider and prepare draft rules for that court at an early stage. As members are aware, the Council's immediate task will be to prepare the draft court rules for implementation of the Scottish Government's planned programme of civil courts reform. One of the proposals under consideration is the creation of a Sheriff Appeal Court, as recommended by the Scottish Civil Courts Review. The amendments ensure that should such a proposal be brought forward at any time, the Council would be able to give it due consideration and make the necessary preparations for implementation. I urge Jenny Mara to withdraw her Amendment 27 and invite the committee to approve my Amendments 1 to 4 and 11.
Any other member wish to contribute? Rod.
Just very briefly indeed, I have difficulty with the statutory duty proposed by Jenny Mara. It seems to me that unnecessarily ties the hand. There may be occasions when consultation would be appropriate, but making a statutory duty before anything is produced by the Council seems to me the wrong way forward.
Thank you very much. Jenny, to wind up, please.
I'd like to press the amendment, convener. I feel that the statutory duty to consult strengthens the new council and strengthens its ties with the public at large. I think organisations' right to be consulted will enhance the public's understanding and appreciation of the civil court rules and make the court process a lot more smoother for those who use it. So I'd like to press the amendment.
Thank you very much. The question is Amendment 27 be agreed to. Are we all agreed?
Yes.
There will be a division. Those in favour of Amendment 27, please show. Those against, please show. 4, 3, 5 against. That amendment is disagreed. I call Amendment 1 in the name of the Cabinet Secretary, already debated with Amendment 27. Cabinet Secretary to move formally.
Formally moved.
The question is that Amendment 1 be agreed to. Are we all agreed?
Yes.
That is agreed. The question is that Section 2 be agreed to. Are we all agreed?
Yes.
That's agreed. Call Amendment 2 in the name of the Cabinet Secretary, already debated with Amendment 27. Cabinet Secretary to move formally.
Formally moved.
The question is that Amendment 2 be agreed to. Are we all agreed?
Yes.
That's agreed. Call Amendment 28 in the name of Jenny Mara, already debated with Amendment 25. Jenny, to move or not move?
Moved, convener.
The question is that Amendment 28 be agreed to. Are we all agreed?
Yes.
We call Amendment 29 in the name of Jenny Mara, already debated with Amendment 25. Jenny, to move or not move?
Not moved, convener.
Very much. Call Amendment 30 in the name of Jenny Mara, already debated with Amendment 25. Jenny, move or not move?
Not moved.
The question is that Section 3 be agreed to. Are we all agreed?
Yes.
Am I going slowly enough?
Nearly.
Just about, nearly, just about. Has faint praise. I call consultation of Council. I'll call Amendment 12 in the name of Margaret Mitchell in a group on its own. Margaret, please to move and speak to the amendments.
Thank you, Convener. This amendment seeks to clarify an issue that I raised during Stage 1. Part 1 of the bill establishes the Scottish Civil Justice Council, led by the Lord President, with a membership of legal and consumer representatives. While the Council's role will be predominantly advisory, it will clearly be a significant player in the law reform world, and its opinion will obviously carry weight. Part 1 of the bill allows the Council to offer advice and make recommendations to Scottish ministers on the development of the civil justice system. So this is a probing amendment to discuss whether the bill would go further than that and introduce a presumption that the Council must be consulted in certain circumstances. For example, if a policy was introduced that would, however, directly or indirectly affect the civil justice system, would Scottish ministers be compelled by law to consult the Council? There are other examples of statutory consultees created by legislation, mainly within planning law, where it is necessary to consult local authorities. Other amendments which will be debated today seek to better define the policy and functions and policy remit of the Council. This amendment has a similar objective. It would clarify that notwithstanding the Council's power to offer its advice, nothing in the Act places a requirement that ministers consult the Council. I would therefore be interested to hear the Cabinet Secretary's view on the effect of the current drafting of the bill in this area.
Now, it may be probing, but you are required to move it.
I move
Thank you very
Convener.
much. Anyone else wish to speak to this? Cabinet Secretary.
Well, I appreciate what Margaret Mitchell seeks with Amendment 12, and I agree entirely that the bill should not oblige ministers to consult the Council. That's why there is nothing in the bill which will have that effect. We have discussed already the subject of the separation of powers, and I'm happy to restate the assurances I've given that the Council is an advisory body and that nothing in the bill will interfere with ministers or Parliament's powers. However, I do not believe there is any doubt within the bill which needs addressed by the amendment, and I would therefore ask Margaret Mitchell to withdraw Amendment number 12.
Happy to withdraw.
If no member objects, that's fine. Thank you very much. Call Amendment 3 in the name of the Cabinet Secretary. Ready to debate Amendment 27. Cabinet Secretary to move formally.
Formally moved.
The question is that Amendment 3 be agreed to. Are we all agreed?
Yes.
Call Amendment 4 in the name of the Cabinet Secretary. Ready to debate Amendment 27. Cabinet Secretary to move formally.
Formally moved.
The question is that Amendment 4 be agreed to. Are we all agreed?
Yes.
The question is that Section 4 be agreed to. Are we all agreed?
Yes.
The question is that Section 5 be agreed to. Are we all agreed?
Yes.
Composition of the Council. I'll call Amendment 31 in the name of Jenny Mara, grouped with Amendments 32, 34, 32, 33, 34, 36, 37, 38 and 39. Jenny, please, to move Amendment 31 and speak to all the amendments in the group if you wish.
Convener, Amendment 31 will afford the Council flexibility in the number of judicial members that are appointed. It changes the current proposal from at least 4 judges to at least 2 and no more than 4. It can be seen as a consequential amendment to facilitate the changes outlined in Amendment 34, which seeks to increase the representation of lay members on the Council. Convener, would you like me to also speak to Amendment 32, 33,
yes,
34?
This is your opportunity to do it. You have to speak
Amendment
to them all at the same time.
32 affords the Council 2 practising advocates instead of at least 2. It can be seen as a consequential amendment to facilitate the changes outlined in Amendment 34. Amendment 33 affords the Council 2 practising solicitors instead of at least 2, and it can also be seen as a consequential amendment to facilitate Amendment 34. Amendment 34 itself will give the Council a greater number of members that do not work specifically within the legal sector. This reflects the desire of many organisations that made representations to the committee regarding the composition of the Council. I think, Convener, it is important to have a breadth of interests represented when we are considering how our civil justice system and court works. I understand one concern with limiting the number of legal professionals on the Council may be that rules of court are too technical to be understood by groups representing litigants. However, I think there are many organisations with legally trained personnel that would bring both the necessary legal knowledge and insight of their particular area of the civil justice system to the Council.
Could I ask you to move Amendment 31, please?
I'd move Amendment 31.
Thank you very much. Anyone else wish to debate? Graham?
I would merely add to what Jenny Mara has already said, that the Cabinet Secretary will be aware that there was a number of witnesses came before us who expressed concern about the enclosed nature of the legal establishment and their inability to influence discussions within that civil court environment. The suggestions that Jenny has made in terms of amendment would open up that closed environment and give opportunity to public members to influence the way forward. And it would seem to me we have this one opportunity that we could show a sign for the future that likely is unavailable to us in the next few years. So I would encourage the Cabinet Secretary to look well in Jenny's suggestion.
Rod Campbell, you want to come in?
I think I ought to declare an interest as a member of the Faculty of Advocates. Whilst I've got some sympathy with the line that there may be too many prescribed lawyers, I also think we should bear in mind that this may be the starting point for the Rules Council, and after kind of rules are up and running, it may be possible to change the mandatory appointees, albeit by secondary legislation. I think that's the better way forward.
Don Finney?
Thank you, Convener. I disagree with Rod. I agree with Graham. I think this is the opportunity. It's to set the position from the outset, and the danger is that you've established a group of legal people without the range, particularly I think of the environmental people who should be engaged in this.
Colin?
Yeah, I'm firmly in agreement with Rod. I think particularly in the initial period, I think it's going to be far more technical, going by what the Lord President was explaining to us in his testimony. So I won't be supporting the amendment.
Margaret?
I think Jenny Mara's amendment look very reasonable, and I'd be interested to hear what the Cabinet Secretary has to say as to why they should or shouldn't be approved.
Well, I think he was going to do that anyway, but I don't mind you saying it. Cabinet Secretary.
Amendments 31 to 33 set the maximum number of lawyer and judicial members at what the bill currently provides as a minimum. Amendment 34 increases the mandatory minimum membership from 14 to 18 and provides that none of the Lord President's discretionary appointments may be judges, practising solicitors or advocates. This group of amendments would fundamentally alter the Council's membership and would deprive the Council of the flexibility and capability the Scottish Government believes is necessary for it to carry out its functions most effectively. Amendment 34 also specifies that none of the Lord President's discretionary appointments may be judges or practising advocates or solicitors. And I think this was a point touched upon by Graham Pearson and indeed John Finney. Removing practising solicitors in particular from being eligible for appointment as LP members could lead to a number of worthy candidates who would not sit in the body as representatives of the profession being precluded. For instance, lawyers who work for voluntary organisations or consumer bodies or academics or environment bodies who also practice might be unable to become a member. And I'm sure that was not what was intended. The provision for flexible appointments strikes the right balance to allow the Council to take account of the range of interests in civil justice and have the technical expertise for its detailed work without creating an unduly large and unwieldy body, and it will allow the membership to evolve as its role develops. And I've no doubt Mr Pearson and Mr Finney will both know that frequently lawyers are appointed and employed by these organisations precisely because they add value to the organisation's aims and ethos, and to preclude them, I think, would be detrimental to that interest group. So I note that lay membership of the Civil Justice Council in England and Wales was strengthened following the Spencer Review recommendations in that regard. However, I would point out that the bill as it stands would allow up to 11 non-legal persons to be appointed, over half of the maximum membership of 20. The establishing legislation for the Civil Justice Council in England and Wales specifies only the categories of members, not the numbers. The numbers and therefore the balance are set by ministers in consultation with the Lord Chief Justice. Further, and importantly, the body does not have responsibility for drafting rules of court. The arrangements for the Civil Procedure Rule Committee therefore need to be borne in mind when making comparisons across the border. The committee has between 6 to 9 judicial members, 6 lawyers and 2 lay members. I've personally heard from a variety of groups seeking greater representation on the Council, including the judiciary, the profession and indeed, as was raised with me by Rod Campbell, the insurance industry, who have been in touch with many members. I consider the range of views expressed and the lack of consensus around the issue indicates the need for flexibility. And I believe that flexibility is achieved by allowing the Lord President the discretion provided for within the bill. The membership of such a body, with its technical drafting role and a policy function, must reflect both roles, and the bill provisions allow the Council to evolve as its focus shifts from the initial rule drafting task towards its function of systematic review. The argument has been made that the technical work can instead be carried out through the Council's committees. That may be true, and it is equally true for activities other than rules preparation. But given the technical work will be this body's bread and butter for the next 2 to 3 years, it would seem appropriate that the membership adequately reflects that. Of course, users and the public interests must be included at the heart of this body's work. I expect that there will be an adequate number of lay members on the Council and that court users' interests will be represented by all members of the Council, not just the lay members. That is why the bill requires the Council to have regard to the principles of fairness, accessibility and efficiency when carrying out all its functions. Capping the number of judicial, advocate and solicitor members would limit the Council's capacity to carry out the complex technical work needed to implement the many procedural changes that civil courts reform will require, and could impact on those organisations that many wish to see represented. The bill, as drafted, provides for an appropriate balance of technical expertise in the membership, both on the rule of court and policy issues. This bill will allow the Council to evolve as its focus changes over time. As the Lord President identified in his evidence before the Justice Committee, after the proposed programme of civil courts reform has been implemented, the membership composition of the Council may require to be amended to reflect changing priorities, and ultimately ministers will retain the ability to amend the membership through subordinate legislation if necessary, as mentioned by Rod Campbell. I therefore urge the committee not to support these amendments.
Jenny, please, to wind up.
Thank you, Convener. Before I decided whether to move these amendments or not, I was interested to hear if the Cabinet Secretary might be open to making the provision for lawyers. He explained that this precludes lawyers who work for external organisations but who might still be practising from being included in these provisions, and would he be open to perhaps putting in the provisions lawyers who are only who are also practising?
Well, I'm happy to give consideration to anything. I think you're either a lawyer or you're not a lawyer. And if you specify that you can't be a lawyer, then I think that rules you out whether you're there as a representative of the faculty, the Law Society of Scotland, or indeed are representing a consumer group or environmental group or something else. I think it would be very difficult to draft that, but I'm happy to consider such matters. But as I say, people tend to wear a particular hat. If you're a lawyer, you're a lawyer, unless you were specifying the Law Society of Scotland or other matters. So as I say, that's a matter I can reflect upon. But as I say, I think it is also the other particular matter, which is the Lord President has to have some flexibility to deal with the claims that we know are being made from the Association of British Insurers, from those representing consumer interests. He is aware of the competing groups. They will ebb and flow as time and issues matter. And I think that's a matter for him, but I'm happy to reflect upon that.
Convener, I thank this Cabinet Secretary for reflecting on that. In the meantime, I'd like to move the amendment.
Well, you've moved it. You're pressing it now.
Yeah.
The question is Amendment 31 be agreed to. Are we all agreed? Yes. Those in favour, please show. Those against, please show. Abstentions? It's 1. Now it's 3 in favour, 4 against, 1 abstention. That amendment is disagreed. I call Amendment 32 in the name of Jenny Mara. Already debate Amendment 31.
Sorry, was that not 3 in favour, 3 against?
No.
And 1?
4. 1, 2, 3,
right,
4,
okay.
1 abstention.
Okay, thanks.
Don't mind being corrected. No. I've got 2 people correcting me now. If anybody else wants to join in, feel free. Am I going slowly enough?
Not quite for me, obviously.
I'm just checking. Call Amendment 32 in the name of Jenny Mara. Debated with Amendment 31. Jenny, move or not move?
Moved, Convener.
The question is Amendment 32 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 32, please show. Those against, please show. Abstentions? That's 3 for, 4 against, 1 abstention. That amendment is disagreed. Call Amendment 33 in the name of Jenny Mara. Already debated Amendment 31. Jenny, to move or not move?
Moved, Convener.
The question is Amendment 33 be agreed to. Are we all agreed?
Yes.
There will be a division. Those in favour, please show. Those against, please show. Abstentions? 3 for, 4 against, 1 abstention. That amendment is not agreed to. Call call Amendment 34 in the name of Jenny Mara. Already debate Amendment 31. Move or not move, Jenny?
Moved, Convener.
Question is Amendment 34 be agreed to. Are we all agreed? Yes. There will be a division. Those in favour, please show. Those against, please show. Abstentions? 3 and 4, 4 against, 1 abstention. That amendment is disagreed. The question is that Section 6 be agreed to. Are we all agreed?
Yes.
Now to appointments by Lord President. I call Amendment 35 in the name of Jenny Mara, group with Amendments 5 and 13. Jenny, please to move Amendment 35 and speak to the other amendments in the group.
Thank you, Convener. Amendment 35 will ensure there is gender parity on the new council. This amendment will guarantee that membership of the council is gender balanced, with a minimum 40% of men and women being appointed. The other 20% would be flexible. There still exists a large gender gap in Scotland's legal sector, not least in its governing bodies that the government has power over. For example, as of June this year, the Judicial Appointments Board comprised 70% men, the Legal Complaints Commission 66% men, the Law Commission 80% men, the Scottish Court Service 68% men, and I could go on. I think it is also true to say that many cases that go through our courts can affect women disproportionately. I think it would show leadership and foresight if we were to ensure gender parity on this public body. Convener, I'd like to move Amendment 35.
Thank you very much. Cabinet Secretary, please to speak to Amendment 5 and other amendments in the group.
Amendment 35 deals with a very important issue which we've discussed before in relation to the Scottish Police Authority and the Scottish Fire and Rescue Service when considering the Police and Fire Reform Scotland Bill, and I remain of the view that equality of opportunity for women and men, and indeed for many different groups, needs to be addressed. But I'm not persuaded that quotas for specialist expert bodies is the right approach. I hope that Amendment 5 in my name, which inserts the principle that appointments are to be made fairly, and which I'll speak to more fully in a minute, will help to address some of Jenny Mara's concerns in this area. Margaret Mitchell's Amendment 13 would require the code of practice for making ministerial appointments set by the Office of the Public Appointments Commissioner for Scotland to apply to the Lord President's Statement of Appointment Practice, as far as practicable and with such modifications as the Lord President considers appropriate. It would also require the Lord President to consult the Public Appointments Commissioner for Scotland before publishing the statement. The majority of appointments to the Council will be made by the Lord President rather than Scottish ministers, who will appoint one member of staff of the Scottish Government. The Lord President indicated to the committee his intention to draw on the principles contained in the OPCA State Code of Practice in making appointments. I welcome that commitment. However, I do not agree that these appointments should be tied by statute to the OPCA's Code. The Code is specifically designed for ministerial appointments to public bodies and is non-statutory and may change from time to time. It would not seem appropriate to bind the Lord President in primary legislation to a set of principles which are not themselves in primary legislation, are designed for a different purpose and are susceptible to change, nor to introduce a role for the Public Appointments Commissioner in this regard. Instead, and noting the concerns of Margaret Mitchell and others, I offer Amendment 5, which adds to the commitment already made by the Lord President and embodies what I consider are appropriate principles to guide the making of appointments while ensuring a proportionate approach is maintained. And by specifying that the Lord President, when drawing up his statement of appointment practice, he must have regard to the principles that appointments should be made fairly and openly, and all eligible persons should have the opportunity to be considered, I would submit that Amendment 5 goes further than Amendment 13 in some respects, and I therefore urge the committee not to accept Jenny Mara and Margaret Mitchell's amendments and invite it to improve Amendment 5.
Margaret, please, to speak to Amendment 13 and the other amendments in the group, if you wish.
Thank you, Convener. This amendment seeks to address the widespread concerns over the process of appointments to the Council. Many witnesses told the Justice Committee at Stage 1 that the process should be more prescriptive and, in particular, should comply with the guidelines set down in the Public Appointment Commissioner for Scotland's 2011 Code of Practice. I note that the appointments to the Civil Justice Council in England and Wales are expected to comply with standard public appointment procedures. The Commissioner's guidelines also apply to appointments to comparable organisations such as the Scottish Legal Aid Board, the Scottish Legal Complaints Commission and the Judicial Appointments Board for Scotland. The Scottish Government has taken the view that the Council should be given the status of a statutory advisory body rather than a non-departmental public body. Significantly, this departs from the recommendations of the Gill Review, and the effect of designating the Council a statutory advisory body is that the important accountability mechanisms will not apply, including the public appointments procedure. The Council has been described as an NDPB in all but name, and there is clearly little distinction between the Council, which is to be an arm's-length body with an advisory remit paid for by the public purse, and other NDPBs. The Council will have an advisory role in an important part of our justice system, and appointments must be made in an open and transparent way. I accept the Public Appointment Commissioner for Scotland regulates ministerial appointments, and this is why the amendment in my name does not seek to bring the Council completely within the remit of the Public Appointments and Public Bodies, etc. Scotland Act 2003. However, it is important that appointments are made within the rules laid down by the Commissioner as far as possible. My amendment would require the Lord President to prepare and publish a statement of appointment practice, which would, as far as appropriate, follow the Commissioner's Code of Practice. The words "as far as appropriate" are included to provide the necessary flexibility for appointments made by the Lord President. The amendment is therefore, I would contend, similar to Amendment 5 in the name of the Cabinet Secretary, which broadly states the Code of Practice and requires the Lord President to have regard to the principles embodied in the Code. However, the significant difference between our amendment is that Amendment 13 additionally requires the Lord President to consult the Amendment Appointments Commissioner for Scotland when drawing up his statement. This is important because it will involve an independent external expert in the appointment process and help provide the transparency we need and which is necessary for the Council. And for that reason, I would reject the arguments from the Cabinet Secretary on that specific point. Without this additional provision, the Lord President would be tasked with interpreting the Code of Practice in both, one, the drawing up of the statement of appointment practice, and two, in making the actual appointment. And this seems to me largely to amount to a tick box exercise which does not provide transparency at all. By contrast, the amendment in my name, the Commissioner will be able to advise and make recommendations to the Lord President. Finally, I understand that the terms of the remit of the Standard Procedure and Appointments Committee would enable parliamentary scrutiny of the appointments made by the Lord President if the committee so wishes. I would therefore welcome confirmation from the Cabinet Secretary as to whether or not the Scottish Government shares this view, as I think it's important Parliament has a mechanism to consider and report on these appointments. I move Amendment 31.
You don't need to move it just now, just speak to it at the moment. Do you wish to respond to anything in that, Cabinet Secretary, before I move to other members?
Well, I think these are matters that the Lord President has indicated a willingness to be as open, as fair, as accessible as possible. I have no doubt that he will, be appearing before this committee on a variety of matters, and doubtless would be prepared to, discuss in respect of that. I do think this is about just showing some respect, keeping the separation of powers, and that is why I think the current amendment in my own name provides the assurances that are necessary.
Anyone else wish to come in this particular debate? Jenny, please, to wind up.
Thank you, Convener. I would support the remarks of Margaret Mitchell on the Code of Practice and the public appointment and public bodies. To go back to my amendment 35 on gender parity, I heard no reason from the Cabinet Secretary as to why this should not happen, and he's heard me make this argument on the previous bill that went through this committee. The figures that I read out are overwhelming evidence that not enough is being done to ensure a balance of representation for gender on our public bodies. And I think this would be an easy and simple way to redress this imbalance in our legal system. And I would urge the Cabinet Secretary to reconsider supporting Amendment 35.
So you're pressing it?
Yes.
Right. Question is that Amendment 35 be agreed to. Are we all agreed?
Yes.
There'll be a division. Those in favour, please show. Those against, please show. 2 for, 6 against. That amendment is disagreed. Call Amendment 36 in the name of Jenny Mara. Already debated Amendment 1. Jenny, to move or not move?
Not moved, Convener.
Call Amendment 5 in the name of the Cabinet Secretary. Already debated Amendment 35. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 5 be agreed to. Are we all agreed?
Yes.
We are agreed. Call Amendment 13 in the name of Margaret Mitchell. Already debated Amendment 35. Margaret, to move or not move?
Moved.
The question is Amendment 13 be agreed to. Are we all agreed?
Yes.
We are not agreed. Those in favour, please show. Those against, please show. 3 in favour, 5 against. That amendment is not agreed to. Call Amendment 37 in the name of Jenny Mara. Already debated Amendment 31. To move or not move, Jenny?
Not moved, Convener.
The question is that Section 7 be agreed to. Are we all agreed? The question is that Section 8 be agreed to. Are we all agreed? Call Amendment 38 in the name of Jenny Mara. Already debated with Amendment 31. Jenny, move or not move?
Not moved.
The question is that Section 9 be agreed to. Are we all agreed? Thank you. Call Amendment 39 in the name of Jenny Mara. Already debated with Amendment 31. Move or not move?
Not moved.
The question is that Section 10 be agreed to. Are we all agreed?
Yes.
Moving on to Section 11, Chair and Deputy Chair of Council. I'll call Amendment 6 in the name of the Cabinet Secretary, group with Amendments 7, 8, 9 and 10. Cabinet Secretary, please to move Amendment 6 and speak to the other amendments in the group.
I begin with Amendment 9. Section 11 of the bill as it stands provides that the Lord President may determine that he or any Court of Session judge member of the Council is to chair Council meetings. It also provides that a Deputy Chair is to be elected by the Council from the judicial members. Having considered the views expressed in evidence regarding the role of lay members in the Council, I agree with the Committee's view expressed in its Stage 1 report that lay members should not be precluded from the position of Deputy Chair. Accordingly, Amendment 9 removes the requirement that a Deputy Chair is to be elected from the judicial members of the Council and leaves the selection of the Deputy Chair to the Council. Amendments 6, 7, 8 and 10 are drafting amendments to remove any doubt as to the ability of the Deputy Chair to chair meetings of the Council. I move Amendment 6.
Very much. Any other members wish to speak? Nobody's indicating it. I take it you don't wish to wind up. Cabinet Secretary. The question is that Amendment 6 be agreed to. Are we all agreed?
Yes.
Call Amendments 7, 8, 9 and 10, all in the name of the Cabinet Secretary and all previously debated. Can I invite the Cabinet Secretary to move the amendments 7 to 10 en bloc?
Moved en bloc.
Does any member object to a single question being put on amendments 7 to 10? The questions amendments 7 to 10 are agreed to. Are we all agreed?
Yes.
Thank you very much. That's it. The question is that Section 11 be agreed to. Are we all agreed?
Yes.
Proceedings in public. I call Amendment 40 in the name of Jenny Mara in a group on its own. Jenny, please to move and speak to that amendment.
Thank you, Convener. Amendment 40 has been taken from a government-supported amendment to the recent Police and Fire Reform Scotland Bill that came through this committee. It seeks to add a layer of transparency to the Council's proceedings by affording it the ability to hold proceedings in public and the ability to publish details of proceedings and other related materials. Given the complexity of some rules of court, I think there is added advantage for the public and for lay organisations for council meetings to be held in public. They will gain a greater understanding of the thinking behind the changes to rules of court and our civil justice system, which will, in turn, filter down to court users and the public at large. We should expect the same level of transparency from all the public bodies we create. Doing so ensures consistency in the government's approach to transparency and accountability. Given this amendment has made its way into the Police and Fire Act, I would expect it to make its way into this bill too. I move the amendment in my name, Convener.
Good, excellent. Anyone else wish to speak to this? Cabinet Secretary.
While I agree that there are good arguments for certain public bodies to hold proceedings publicly, I am not persuaded that the new Council, which will be essentially advisory in nature, should be required to do so. Generally, those bodies required by statute to hold proceedings publicly, local police or fire boards, for example, have quite different purposes and functions from those of the proposed Council. Such bodies are responsible for service delivery, including the allocation of public funds. It is therefore correct that the public should be given a right of access. The Council, while it will consider and advise on important issues, will not be responsible for making final decisions. I appreciate that concerns about the accountability of the Council and the opportunity to scrutinise it are at the root of this amendment. I hope I can lay some of these concerns. The Council will be required to lay an annual report and business plan before Parliament. Under Section 5(3), the report must include a summary of any recommendations the Council has made. The report and plan and the Council's recommendations will therefore be published, and if Parliament wishes to publicly consider any of the issues raised, it will do so. Court rules are already laid before Parliament and published, and the Parliament's consideration of those rules is a matter of public record. Also, the existing Civil Rules Councils do not currently operate in secret. While they do not meet in public, they publish minutes of their proceedings online. The Lord President has assured me that he intends the new Council will be more proactive in relation to the material about its work which is published. There is also the seemingly small matter of the practicability of Amendment 40. Requiring Council and Committee meetings to be held in public would mean that the Scottish Court Service would have to put in place suitable arrangements for public access. That would pose difficulties in terms of finding suitable accommodation. And especially during civil courts reform, when meetings could take place very regularly, this would add to the costs of the body. Lastly, I would mention that there is nothing in the bill which would prevent the Council holding public meetings if it wishes. Some of those calling for more robust accountability mechanisms are exactly the sorts of people I expect might become members of the Council or its committees. I therefore trust that this is a matter that can be left to the Council. All of that said, I do agree with Jenny Mara that the new Council should carry out its activities in an open and transparent manner. That is why the bill introduces a new requirement for the laying of plans and reports before Parliament. That's why I brought forward my own Amendment 5 in respect of appointments being made fairly and openly. And that is why the Scottish Government has decided to extend FOI coverage to both the new Council and the Criminal Courts Rules Council. That will be done by subordinate legislation to be brought to Parliament in the new year. And I would be happy to provide a draft order before Stage 3 proceedings, should that be desired. I do not believe we are in disagreement over the principle of Amendment 40. The question is rather about the best and most proportionate means of achieving the same end. I believe all the arrangements I have discussed will provide for robust mechanisms for ensuring proper scrutiny and accountability, and in terms of freedom of information in particular, that will be more robust, as the Council will not have the discretion provided for by Amendment 40. I therefore urge Jenny Mara to withdraw her amendment.
Jenny, press or withdraw?
Convener, I'm going to press my
amendment. Wind up, sorry, I beg your pardon. You want to say them further?
Yeah, I'm going to press my amendment. I think it is the most robust and confident arms of government and government institutions that welcome meetings in public and opening themselves up to the highest level of scrutiny and accountability. And I think as many of our public organisations should meet in public as possible. I don't think the Cabinet Secretary's argument as to cost would necessarily stack up. I think there are many meeting venues within our court system that would quite easily be accessible to the public, and I don't take that as a good reason not to be robust in transparency. That said, I would like to move the amendment in my name.
You're pressing it, that's fine. You're
Okay.
pressing it, okay? Question is Amendment 40 be agreed to. Are we all agreed?
Yes.
Those in favour, please show there's a division. Those against, please show. 3 in favour, 5 against. That amendment is disagreed to. The question is that Section 12 be agreed to. Are we all agreed?
Yes.
The question is that Sections 13, 14 and 15 be agreed to. Are we all agreed?
Yes.
I call Amendment 11 in the name of the Cabinet Secretary, already debated with Amendment 27. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 11 be agreed to. Are we all agreed? Yes. We are agreed. The question is that Section 16 be agreed to. Are we all agreed?
Yes.
The question is that Sections 17 and 18 be agreed to. Are we all agreed?
Yes.
We are agreed. Thank you. Threshold for contributions. I've got a short, I've just about, yes, I didn't read my little scribble. My little scribble says, short pause to change officials. And that's exactly what we're going to do, but we're staying put. We'll have a 1-minute suspension. We're all sitting comfortably, so we'll begin. I call Amendment 41 in the name of Jenny Mara, group with Amendments 42, 43, 44, 19 and 20. Jenny, please to move Amendment 41 and speak to the other amendments in the group.
Thank you, Convener. Amendment 41 removes the £68 contribution threshold for ABWAR payments from the face of the bill, and can be seen as a consequential amendment to facilitate Amendment 42, which seeks to have the rates of contribution set by regulation instead. Amendment 42 seeks to have rates of contribution for ABWAR in relation to disposable income or capital set by regulation rather than primary legislation. It is my view that regulations are easier and more commonly amended than primary legislation. When we look at contribution rates for civil justice, where the rate is set by altering primary legislation, we can already see that it hasn't been amended this year, in spite of wage freezes and increasing costs of living. If we have £68 threshold on the face of this primary legislation, this figure will be out of date in 3 months, never mind 6 months, a year or 3 years, as prices and the cost of living rise in this recession. It is not common to change primary legislation, and therefore figures which in the interests of justice need to be regularly reviewed are much better contained in regulations. Amendment 43 and 44 have the same effect for criminal legal aid as Amendments 41 and 42 do for ABWAR, and I would move Amendment 41 in my name.
Thank you very much. Margaret, please. Margaret Mitchell to speak to Amendment 19 and other amendments in the group. Margaret.
Thank you very much, Convener. This amendment, along with Amendment 20, will require Scottish ministers to make regulations explicitly stating what is meant by disposable income and disposable capital in the bill. I accept that the definition of disposable income will inevitably be complex, which is why I'm not suggesting it be included on the face of the bill. However, I think it's important to have a legally binding definition and that Parliament be given the opportunity to consider this definition. The definition of disposable income is central to how this legislation will work, as it determines at what point an individual is required to contribute to their legal representation. If the threshold is wrong, it could result in poor and vulnerable people being forced to pay when they are unable to afford to do so. The Cabinet Secretary and the Scottish Legal Aid Board have assured this committee before that disposable income would be determined only after deducting a long list of necessary costs. However, the evidence the committee has received shows that stakeholders disagree on what exactly should be included in disposable income. For example, some witnesses have expressed concerns that non-passported benefits are to be taken into account as income, while others call for the disability living allowance or its replacement to be disregarded. The inclusion of the resources of spouses or partners could also cause confusion and, I believe, be controversial. Does this mean if the total household disposable income exceeds the threshold, one member of the household who has been accused of a crime but earns below the threshold will have to make a contribution? There is equally as much confusion over what is to constitute disposable capital. The policy memorandum to the bill states disposable capital will include savings and anything else of value owned by the client, with some essential exceptions. This in turn could result in elderly individuals who may have significant capital but low disposable income being forced to contribute to legal aid. These questions cannot be left to interpretation and should be set out in subordinate legislation. In the interests of clarity, the Cabinet Secretary must come up with a definitive list that can be debated, and so that those accused of a crime know exactly what will be taken into account as income and capital and what will not. Amendment 19 would oblige ministers to make regulations about contributions for criminal legal assistance. The bill currently gives ministers this power without requiring regulations. Amendment 20 would ensure that ministers include a definition of both disposable income and disposable capital in these regulations. In relation to the amendment in Jenny Mara's name, while I am very sympathetic to the intent behind these, they would result in uncertainty as to the precise threshold and at this point in time, and for this reason I cannot support them.
Thank you very much, Margaret. Anyone else wish to come in at this stage? Cabinet Secretary.
These amendments focus on the threshold above which a person's contribution towards their criminal legal aid fees will be assessed. Many comments have been made on the minimum threshold proposed during evidence sessions, and it was a subject raised by many of my colleagues in the Stage 1 debate. As I stated in my response to the committee's Stage 1 report, a number of principles have been applied in reaching the figure of £68, achieving consistency and contribution thresholds between the different aid types used in criminal cases, currently ABWOR when pleading guilty and criminal legal aid when pleading not guilty. Achieving consistency with the level of income support, as this is a level at which state support for a person is essential. £68 is just over the personal allowance level for a single person over 25 at 2011-12 rates. Avoiding sharp differences in contribution based on small differences in income or capital. This has led to the development of the graduated approach the committee will have seen in the draft regulations forwarded recently. Basing a decision such as this on a set of principles means that those principles will continue to apply whenever changes to the threshold might be necessary to maintain access to justice for those in need of criminal legal aid. Principles not only provide the impetus for future changes, but also ensure that any changes are justifiable and timeliness. Indeed, the link to income support levels will likely see an increase in that threshold sooner rather than later. I see that the amendments proposed do not suggest an alteration to the level of threshold, but focus on how that is presented in the bill or in regulations. It's interesting and surprising to see Amendments 41 and 43 lodged by Jenny Mara, which propose removing the minimum threshold from the face of the bill and place the determination of disposable income and capital in regulation. Legal aid legislation is very complex, and much of the detail needs to be set out in regulations. However, where possible, the 1986 Act shows on its face the threshold over which a person may be eligible for a particular legal aid type, and over what threshold a contribution will be due. This is currently done in the Acts for Advice and Assistance, which includes ABWOR, and for civil legal aid. Sections 19 and 20 of the bill continue this important practice. As a result, I think it important that the bill clearly specifies the level of income as the level below which contributions cannot be levied, with the regulations providing the means to alter that level. Amendments 41 and 43 also remove the direct link in sections 19 and 20 to the provisions of the Act which passport those in receipt of specified benefits, ensuring that no contribution is required for them. Amendments 42 and 44 are related to the removal of the thresholds from the face of the bill proposed by Amendments 41 and 43, and do not improve what we have in the bill in terms of describing the content of regulations. Substantial amendments would need to be made to the draft regulations that the committee has been forwarded, for example, to ensure that those people in receipt of passported benefits are not required to pay any contribution. As I've said already, the consequence of that would be that it was no longer clear on the face of the Act that some people will not have to pay any contribution. In my view, these amendments do nothing but remove the clarity of levels where no contribution is due. Therefore, I would urge the committee to retain the threshold as it is in the bill and reject amendments 41, 42, 43 and 44.
Did you address, I can't call it, the contributions, the income of a wife and capital? I think that was raised by Margaret Mitchell. Can't remember if that was addressed.
Well, where there is a conflict, it's, I think, been made quite clear that that will not be taken into account. And we also have, from the Scottish Legal Aid Board, the undue hardship matters that would also be a matter where the board could consider. And that.
Margaret, do you want to? I thought I'd raised that as it hadn't been
It's quite clear,
If I could just include in the
regulations, subsection 4, the resources of any spouse or civil partner of the person concerned shall be treated as that spouse's resources unless the spouse or civil partner has a contrary interest in the matter in respect to which the person is considered as applying for criminal legal aid, or the person concerned and the spouse or partner are living separate and apart, on all the circumstances of the case. It would be inequitable or impractical to do so. So, as I say, where there is a conflict such as domestic violence, they would not be taken into account. And in other matters that are difficult to speculate on, there is still the opportunity to approach the board.
For the avoidance of doubt, Cabinet Secretary, if there's husband and wife living together, the wife is earning less and would normally qualify to have legal assistance, will it be a household income and she could be liable? That's the real point.
Well, it is a household income, except where in those criteria either they are living separate or apart, there's a conflict of interest, or, as I say, where there is some other matter that the board could reflect upon. But deductions are made in terms of the assessment of disposable income for a spouse, as deductions are made for children. So the basis of the individual applying for legal aid is that, first of all, matters are assessed irrespective of whether there's a contrary interest, with deductions made for the spouse, deductions made for children and other matters. In a particular case where, as I say, there may be a conflict, if they're living separate and apart, then the income is not taken into account.
Okay. Yes. Jenny, to wind up, please. I've forgotten what you're winding up on now. Well, yeah, you ought to really have done it at the time, but I'll let you do it.
Oh, right. Okay.
Right, so if you want to and you're winding up, slip that in. It's just between you and me. Nobody heard me saying that.
Thank you, Convener. If I can just address that point first, I was interested in the Cabinet Secretary's response to Margaret Mitchell's amendment, saying that there's going to be a provision for where there is a conflict of interest to decide whether a wife or a spouse is eligible to make a contribution. I'd be very interested in the Cabinet Secretary's response as to whether that conflict of interest will actually be defined in the legislation or if that will be left to judicial discretion. To turn to my own amendment, where are we?
You're winding up and pressing and withdrawing 41. I've kind of lost what it was myself now. Such a long time
Amendment
ago.
41, Convener. Taking the threshold off the face of the bill. I think the Cabinet Secretary seeks to be slightly mischievous, if I may say so, with the intention of my amendment, saying that it would actually leave people who fell below the £68 threshold to pay a legal aid criminal contribution. I would suggest that taking the £68 off the face of the bill and putting the figures into regulations would leave no scope for that interpretation, because they would be provided for, thresholds would be provided for in legislation, but in the regulations. I would also add the Cabinet Secretary, I think I would ask him before deciding whether to press this amendment, how regularly, given the £68 is going to be on the face of the bill in primary legislation, how regularly would he anticipate that figure being reviewed?
Well, that's not a matter over which I can bind successors. I mean, that's a matter that the board would require to consider and governments would require to address, as has been, since legal aid was first established. In terms of matters, I don't think it's a matter of being mischievous. It's a matter of being quite factual in what's literally there. It would also be fair to say that it's not judicial discretion. This would be discretion for the legal aid board. The only aspect of any judicial discretion would be if somebody was to judicially review this matter and this to be a matter before the appeal court. I would also say, as was raised in the Stage 1 debate, the regulations will provide that war pensions as well as disability living allowance are not included in the calculation of disposable income. That said, I'm happy to work with the committee to reconsider thresholds as we go along. I think if people wish a higher threshold for criminal legal aid, it's my view that that would have to be replicated across the board with civil. I think there would be a gross disparity to expect the victim of domestic violence to be paying a higher level than the perpetrator, allegedly, of that domestic violence. Equally, the caveat would have to be that the cost of any increase would have to be met from the current legal aid budget, which would mean it would have to come out of fees. But I am happy to enter into discussion with the Law Society of Scotland on that and to see if they are willing to share the burden across, as I say, civil and criminal for parity, but to have it dealt with from matters, as I say, that would impact upon their fees. And so I can return to the committee in due course. Amendment 19, proposed by Margaret Mitchell, presents some technical difficulties arise from a conversion from may to must. Firstly, and most importantly, if you want to convert a power to an obligation in legislation, you need to specify exactly what that obligation is. Otherwise, it could be satisfied with minimal effort by Scottish ministers. Such a specific explanation in section 22 and what the regulations must cover would be very long, possibly as long and detailed as the regulations themselves. Secondly, must might be complied with only once and again provides a risk of minimal effort by Scottish ministers. May allow Scottish ministers to exercise the power repeatedly as and when is necessary. Thirdly, regulations would need to be ready at the same time that the obligation in the bill, by then an act, to make them comes into force. Otherwise, Scottish ministers would be in breach of that obligation as soon as it has effect. In any event, the system will simply not work without regulations, so there's nothing to fear from the use of the word may in the legislation. On Amendment 20, also put forward by Margaret Mitchell, I see no need to include a definition of disposable income and capital in regulations. There is a definition of disposable income and capital contained in Section 42 of the Legal Aid Scotland Act 1986, and that provision includes a power to prescribe in regulations what constitutes disposable income and disposable capital. In practice, this power has to be used before the contributions regime or the new test for criminal abhor can operate. The Section 42 power would be used when making the draft regulations which have been shared with the committee. Section 42 has been in the Act since enactment in 1986 and has been exercised already for advice and assistance regulations and civil legal aid regulations which contain long schedules similar to those schedules already contained in the draft regulations. And I would ask the committee to reject Amendments 19 and 20.
Now, as we've sort of gone back to the in a circle back to the Cabinet Secretary addressing things, I'll let the other two members come back in if they so require. Margaret, you've had more stuff now said.
Notwithstanding what you've said, Cabinet Secretary, I think there's an overriding requirement to make sure we constitute exactly what's meant by disposable income and capital, and therefore I'll be pressing both amendments.
Well, we've not got to that yet, but you're not persuaded.
Not persuaded.
Jenny.
Thank you, Convener. Cabinet Secretary, just for clarification, can I ask, did you say that you're prepared to enter into discussions on taking the £68 limit off the face of the bill?
Yeah, I'm prepared to enter into discussions with the Law Society of Scotland, not to take the figure off, but to increase which would be dealt with through regulations. But I'm happy to enter into that. There's good reason, as was explained, why that 68 goes in. But I'm happy to consider, but the caveats I'm putting forward in terms of any increase will be: one, there will be parity with civil, and two, it will have to come out of the existing budget, which means three, it comes out from the fees that are currently paid to the profession. But I'll enter into that discussion.
Okay, thank you. Just for further clarification, so you'll enter into discussions to keep the figure on the face of the bill, but review it on a regular basis?
Well, it is to be reviewed. As I did touch upon, these matters will also be dependent upon what may happen in benefit changes and increase in the levels of allowances paid there. We think it's important that the figure is kept on the face of the bill because of the tie-in it has with a whole variety of minimum matters. The changes in the Henry uprating would be through regulation. I'm happy to enter into discussion about increasing matters, but I think the principle should remain on the face of the bill.
On the face of the bill? And how regularly would that review take place?
I can't address the view because that's for governments. It also depends upon when benefit changes come through. And given the proposals of the coalition government, it might be in a negative way, as we'd have to be considering matters. So some of these factors are not within my control because there are aspects that are beyond the powers of this Parliament.
Okay. I thank the Cabinet Secretary for his clarification. In the meantime, before these discussions, I'm going to press the amendments.
All right. You're pressing the amendment. The question is that Amendment 41 be agreed to. Are we all agreed?
Yes.
We are not agreed. Those in favour, please show. Those against, please show. Abstentions? 2 for, 5 against, 1 abstention. That amendment is disagreed. I call Amendment 42 in the name of Jenny Mara, already debated with Amendment 41. Move or not move?
Moved.
The question is that Amendment 42 be agreed to. Are we all agreed?
Yes.
We are not agreed. Those in favour, please show. Those against, please show. Abstentions? 2 for, 5 against, 1 abstention. That amendment is not agreed to. Call Amendment 14 in the name of Margaret Mitchell, group with Amendments 15, 16, 17, 18, 21 and 22. Margaret, please to move Amendment 14 and speak the other amendments in the group.
Thank you, Convener. Amendments 14 to 18 and 21 and 22 seek to alter the way in which the bill deals with the determination and collection of contributions. In short, the amendments will require the Scottish Legal Aid Board to determine and collect any contributions payable under the bill. The amendments will not require SLAB to collect the limited contributions currently collected by solicitors, mainly because this amounts to just over 5% of the amount the bill would require solicitors to collect. The Scottish Legal Aid Board is best placed to determine and collect legal aid contributions. SLAB has a 95% collection rate in civil legal aid cases and therefore already has the apparatus and collection procedures required to carry out large-scale collections of contributions. SLAB was established by statute to administer legal aid funds. It is, therefore, it seems to me, frankly preposterous that the government is proposing that private business should determine and collect such a large percentage of legal aid contributions. And let's just spell out exactly the risks of the government's proposals. It will mean criminal legal aid solicitors who have accepted significant cuts to their fees in recent years will be required to collect around £2.7 million in summary legal aid and aid by way of representation criminal contributions. And the result of the government's proposal will be that criminal legal aid solicitors will either be unable to contribute, to collect contributions in a significant number of cases, or will have to delay proceedings in order to secure these contributions. For there is no doubt that requiring solicitors to collect summary criminal legal aid contributions is almost certainly going to result in court delays and increases in cases where the accused persons represent themselves. As a member of the former Justice 1 Committee, which scrutinised and supported reforms to the High Court and summary courts intended to address delays in these courts, it beggars belief that the SNP government, with its ill-judged proposal, is undermining this constructive and effective legislation which has resulted in significant reductions in trial adjournments in recent years. In addition to this, the proposed system could also discourage solicitors from taking on legal aid work, which is already low paid compared to other legal work, and this raises very definite access to justice issues. Understandably, the proposal is strongly opposed by the legal profession. The Edinburgh and Glasgow Bar Associations have already indicated they intend to strike if the plans go ahead. And while I do not condone the strike action, it is a reflection of the serious opposition to the government's proposal. The committee's Stage 1 report invited the government to reflect further on this issue. The Scottish Government's response to all this is that solicitors already have systems in place for collecting client contributions and that around 82% of clients will not have to make any contributions under its plans. I question both these assertions. According to a survey by the Law Society of Scotland, over 70% of respondent firms stated they either never or rarely collect avoir contributions because it was simply too difficult to do so. The government's claim that 82% of clients will not have to make any contributions is based on modelling of 4 medium-sized firms only, and as such, it is not extensive or representative enough to be relied on. Taking all of this into consideration, there can be only one explanation for these disruptive and damaging proposals, namely that the government does not want to foot the bill for the additional resources for SLAB to determine and collect contributions. Nor is it in any way a surprise that SLAB supports some of its work being done by lawyers, given that in 2011-12 the Scottish Government reduced SLAB's budget and having frozen it in the 3 years prior to this cut. In effect, what is being proposed amounts to a cut in legal aid fees in the form of the introduction of contributions. Solicitors are then expected to collect contributions in order to ensure they are fully paid, and the government is saying tough luck if they are unable to do so. I accept there would be significant resource implications in requiring SLAB to collect the majority of contributions, but equally, this is the fair and most efficient way to proceed, and the Scottish Government must now, I believe, surely accept this fact and provide adequate resources for SLAB to do its job. Amendment 14 would require SLAB to determine and collect contributions for criminal avoir introduced by Section 19 of the Bill. Like the other amendments in the group, this is drafted to include both the determination and collection of contributions, as both would provide unnecessary burdens on lawyers. Amendment 15 would require SLAB to determine and collect contributions for criminal legal aid introduced by Section 20. Amendment 16 clarifies the fees paid to solicitors are paid by order of the court and by the board out of legal aid funds. Amendments 17 and 18 are consequential to Amendment 16. Amendment 21 makes it clear that regulations about contributions for criminal legal assistance cannot require solicitors to determine or collect contribution. And Amendment 22 removes the subsection which would allow regulations to specify whether it is for the board or solicitors to determine and collect contributions. I move the amendments. My name.
It was move 14.
Move 14 in my name.
Thank you very much. Other members, I've got John Finney first, Rod Campbell, Graham Pearson. John.
Thank you, Convener. Cabinet Secretary, we've had a lot of, as you would anticipate, last-minute submissions from various people. Indeed, I met with the solicitors out the front of the building this morning. One of those contributions came from the Legal Aid Board, and if I can quote to you from the section talking about collection of contributions by PDSO, and I quote here, the PDSO will determine the amount of and collect contributions. In the event of non-payment and where the PDSO has taken reasonable steps to collect and it is cost-effective to do so, the board will pursue the outstanding payments. Now, there seems to have been some confusion around that, and I wonder, and I'm reassured what you've said in relation to the undue hardship and other issues and the review of increasing threshold. One of the things suggested to me this morning as I spoke out the front there was the quote of a previous figure we've heard from SLAB, namely the figure of 600,000 for the collection of fees, and a proposal, and I appreciate this is literally the back of a paper this morning, that were £5 to be removed from every solicitor's fee, then that would pay for the cost of collection by SLAB. Is that something you'd be prepared to consider, given that you talk about the overall cost envelope when you talk earlier when we talked about the thresholds?
Now, would it be useful to the committee, having posed that question, to hear other contributions and then let the Cabinet Secretary come in, or do you want me to? But what do you want? Do you deal with this one first? Or?
Yes. Yeah.
It's fine, whatever suits Cabinet Secretary. And I'll give you a moment, because that's just been put to you. I think, in fairness, take your time. Yes, it's just been put. Do we want to move? I think. Are you? Mr. Matt's taking over. I'll have to limit the muffins. I think they're overwhelmed by them. Yes. Now, are you prepared with this? It was just put to you.
To respond to John Finnegan. What I can say is, I mean...
Sorry, John, yes.
Sorry, Cabinet Secretary. I should say in the matter, it's the principle of further discussions on the issues. I'm not expecting you to negotiate with the Law Society in public.
First of all, I think it was suggested by some in the profession that the PDSO would not be collecting contributions. That is not the case. The PDSO will seek to collect contributions. If people were not to be paying it, then the PDSO are part employed by SLAB, and SLAB will seek to recover that. I think there's a point of principle, and they will seek to enforce that. I think it would be fair to say that the Scottish Legal Aid Board are not a collection agency, and the increased costs that they would have if they were to seek to become a collection agency for all firms, we'd have to see them hire in people to pursue, and there's probably actually private firms that are better placed to be able to do mass debt recovery, which some legal firms do on an industrial scale, and it would be better for them to recover it. What I can say in general discussions is that the point I said to Jenny Mara, I have a fixed envelope of what I need to be able to address and what I need to be able to meet. If the Law Society have any proposals, and so far they haven't had any proposals other than simply refusing this, I'm happy to take that on board. I am going to go to them to offer to vary on thresholds. I am prepared to consider out-of-the-box situations. As I say, there may be an argument that you'd be better to pay that levy to one particular private firm who's already established, who do debt collections from a whole lot of utility companies through to catalogue companies. Those firms are well known and are out there. But if it would preferable, I could put it to the Chief Executive of the Scottish Legal Aid Board that a contribution should be made, and we could hire that in, but it would need to be funded from there, because my principle is that we have to preserve the integrity of the legal aid service.
You are amenable to discussions with...
absolutely.
Thank you very much.
Rod, I've got Rod now, followed by Graham, please.
Just briefly, largely for the record, I wanted to just discuss the current situation in relation to Abwar. We heard evidence that the total amount of contributions under Abwar, which should have been collected by solicitors, was 154,000, and that 6.2% of applications for Abwar grants had a contribution involved, and that's of a total number of grants of 42,853. Well, by my calculations, that means at the present time that the average contribution payable for Abwar would be about £58. And looking at these proposals, we can see that just under half of those with a contribution under the new system will be required to pay less than the current maximum of £142. So whilst it's a significant increase, it's not an overwhelming increase. And I would suggest that the evidence as to the situation regarding collection at the current time is less than satisfactory. Margaret Mitchell referred to the Law Society survey. That's only on the basis of 15% of firms returning. And it wasn't of the 75% then who said they under no circumstances they collect. It was just rarely. I've had letters from a number of lawyers where they really do not provide a full explanation as to the reasons why they don't collect. Some talk about relations with their clients, some talk about the economics of it. But we also had evidence from Dr. Lancaster, the Scottish Legal Aid Board, that between 5 and 10% of many firms' criminal income comes from private clients. So that suggests that there are firms at present able to collect a lower value of contributions than the value of contributions they're currently collecting from private clients. So I think that the case in respect of collections is over-egged. I sympathise particularly with very small firms, and I think that will put certain demands on them, which perhaps it doesn't place on the larger firms. But I just wanted to put those thoughts on the record.
Graham.
Thank you, Convener. First of all, I think that with due respect to what Roderick Campbell has just said about the case being over-egged, one often sees that those who are viewing other people's difficulties don't quite appreciate the impact of these economic restraints. In addressing some of the matters that the Cabinet Secretary covered, I agree fully with Margaret Mitchell and her summary of support in terms of her motion. There was no doubt that from the Law Society's viewpoint, through our discussions and the evidence that they gave us at various stages, they felt that the consultation process did not allow them to feed effectively into discussions, and that the various developments were somewhat of a moving feast and changed as we moved from day to day. One would hope that the government have fully scaled the economic impact affecting particularly those small firms that Roderick Campbell referred to at the end of his submission. We rely very heavily on small firms in rural areas to maintain legal aid support for local courts. And in the event that these firms are unable to continue supporting the work of courts in small courts throughout the country, then that will place a really difficult pressure on our system and will be a real threat to the delivery of justice across Scotland in a way that we all hope will be fair and equitable. And I would hope that the Cabinet Secretary would give more consideration to his current stance, which seems to have already been decided, and our debates have had no impact and no change in the position that he's taken hitherto.
Jenny.
Thank you, Convener. I'd listened to Roger Campbell's point on ABWAR, but I have heard much evidence from defence solicitors in Scotland that many solicitors simply don't collect the contribution on ABWAR that they're entitled to because their clients simply can't afford it. And therefore, to base thresholds on this is not really a reflection of what is going on in our criminal justice system, not a reflection of reality. The Cabinet Secretary says that the Scottish Legal Aid Board is not a debt collector, but under this bill, SLAB will collect solemn contributions, and they have the infrastructure and staff to do so already. Perhaps they're collecting solemn contributions because, given the fees involved, the risk is too large for the contributions not to be collected. And is it the case, Cabinet Secretary, that you're simply just passing the risk of no collection, in summary, off of SLAB and onto private defence solicitors?
Before you answer, Cabinet Secretary, I have a question which has been put in the many submissions we've had, is why is it that civil legal aid contributions are collected by the board and not criminal? If we were to pursue, if it was to be pursued by the government in discussions with the Law Society, this would consideration be given, it's quite controversial, to civil legal aid contributions being collected by firms. Now, there would be parity then between criminal practitioners and civil practitioners. Now, I'm not suggesting that's a solution, but I'm accepting that the legal aid budget is tight. I don't want to see what happens in England to legal aid representation. But there is an argument that if this is going to happen to criminal practitioners, why are civil practitioners any different? And I'd be interested if this has ever been discussed with the Law Society.
Well, there's been some thinking, I think, at Law Society level. That's a matter that and Legal Aid Board level. I'm more than happy to allow them to continue to discuss that. I think there are advantages as well as some disadvantages. The advantages are you immediately have this treated as a fee and people get access to it. So that's something, again, as with John Finney, I'm happy to undertake to discuss with the Law Society of Scotland, whether that's initially through the Legal Aid Board, which would be better, but I'm happy to seek to broker these discussions.
Have you any other comments in relation to the submissions with regard to other issues, or have we dealt with them?
Well, no, I would be grateful. I mean, I think, first of all, I should put on record, given that Margaret Mitchell talked about cuts, last year's legal aid costs were the second highest in the history of legal aid, at just under 160 million. Two-thirds of that 160 million, or almost 160 million, went on criminal legal aid. 14 firms got over £1 million from the public purse. This contrasts, and I think it's rich for those in the parties in government south of the border, with an 8% cut imposed by Westminster on legal aid cuts south of the border, and indeed 17.5% that are going to be imposed in the year 14-15. This is about preserving the integrity of the Scottish Legal Aid Service to make sure that we cater for all our people, including, and I see Ms Mara nodding her head no, including the person who came to my surgery last night, who is paying a contribution as she seeks to get divorced from the person who has perpetrated violence against her. I don't see people arguing for parity there, but we are seeking to preserve the integrity of a budget that has been cut, where legal aid is now not available at south of the border for matters including asylum, clinical negligence, criminal injuries compensation, debt, employment, housing, immigration, family and welfare benefits. I think it's important in Scotland that access is available for justice to people. More people are now able to access legal aid than ever before, and it's important that we recognise that within the tight envelope that is foisted upon us by Westminster, we do seek to look after the interests of all. Amendments 14 and 15 propose changes to another aspect of the bill that's been the subject of some comment. And as stated in response to the committee's Stage 1 report, I do not consider it unreasonable to expect a solicitor to collect his or her fees direct from the client who's being provided with legal assistance. Nor do I consider the collection of fees to be anything other than a routine part of business for most, if not all, law firms. I know that solicitors have lobbied hard to be removed from the bill the responsibility to collect their fees in summary cases from their clients, and instead to place that responsibility in the Scottish Legal Aid Board. These amendments not only provide for that transfer, they also transfer responsibility for the determination of contributions to the Scottish Legal Aid Board. I'd begin by repeating that what the bill proposes is evolution, not revolution. Solicitors have been responsible for the assessment and collection of contributions under advice and assistance since the Legal Aid and Legal Assistance Act 1972. The Legal Aid Scotland Act 1986 added the concept of advice and assistance by way of representation, ABWAR, for which solicitors collect contributions, and of course, in the case of privately paying clients, solicitors will collect the entire fee from their clients. There has been no complaint that solicitors are acting as unpaid debt collectors over the 25 years since the 1986 Act came into force. Regulations providing for children's ABWAR will be introduced during the course of 2013 as a result of the Children's Hearing Scotland Act 2010. Under them, solicitors will be required to assess and collect contributions in respect of both welfare-based and offence-based cases. The assessment and collection of contributions in respect of criminal legal aid in the bill is in line with these other aspects of legal aid. There are few solicitors whose work comprises solely criminal practice and who do not already have processes in place to collect fees from clients in respect of ABWAR. Indeed, there are few businesses that do not have processes in place to collect fees for services they provide to a client or customer. Being a solicitor who registers with the Scottish Legal Aid Board should not entitle you to demand that the public first funds the collection of fees payable to you for the services provided by you to a client. I remain firmly of the view that solicitors are much better placed to collect relatively small contributions from their clients. It's also in their clients' interest. For example, the draft regulations provide flexibility in the collection arrangements, leaving it to be agreed between the solicitor and the client. This gives room for a client's preferences to be accommodated. Perhaps the client would want to pay in cash in person. A client might ask for the solicitor to accept 2 instalments or one, to allow the client to pay for another emergency. If SLAB were to be responsible for collecting all contributions, it's unlikely they would be able to be as flexible with the clients. A more structured and prescribed process would need to be put in place, and the client would have an additional burden of setting up a payment method with SLAB. On the issue of assessments, contributions by the board as well as collection, I think this is unworkable. If the board needs more information from the client, it's the solicitor to act as an intermediary, passing on requests from SLAB and then returning to SLAB whatever the client provides. How is this an efficient use of the solicitor's resources? I realise there are some misunderstandings around the responsibility of the PDSO, and I think I've mentioned that. I can go back to what John Finney said and say I will be happy to discuss this, as I say, with the board and indeed with solicitors. But I think there's good reason why it's dealt with there, but I don't rule anything out. But getting the board to collect all contributions would substantially reduce the level of savings to the taxpayer's purse. But as I say, I have made it clear I'm happy to discuss both on the threshold and indeed on collection. But the savings have to be made to avoid the situation that's playing out south of the border. Some actions have to be taken by those who are responsible for criminal legal aid. And I can also say, Convener, that I remember during my time in practice, and I've not practiced for 13 years, of actually having one of my partners buy somebody's council house and they took the fee off them, as I represented them in a criminal matter on a charge and petition. I think there's something where they were perfectly capable of having the fee paid, and we've got to be able to look at that scenario.
Just for clarification, can I also ask the issue that I raised, whether in these open discussions with the Law Society and Legal Aid Board, the matter of civil contributions will also be raised?
Absolutely. Happy to give you an assurance. I'll undertake to discuss that with them.
Thank you very much. Margaret, to press or withdraw?
Can I comment on some of the
Of course.
points
So, beg your pardon. Yes, I got all lost in the debate there.
Yeah,
yes.
thank you, Convener.
Another senior moment. That's to this fortnight. 1 a week's not bad. Margaret, wind up, please.
Turning to Roderick Campbell's contribution, there may well be some firms who are able to collect contributions, but I'd merely say to him the exception doesn't prove the rule. And it's quite clear that from the vast majority of solicitors, they have said loud and clear this proposal will cause them major problems, leading to inevitable delays in the court system and also raising very serious issues about access to justice and the concern that many of these solicitors who currently carry out criminal legal aid work will simply walk with their feet. In terms of the Cabinet Secretary's comments, then I'm advised that there may be some limited cases in which collection by solicitors may be necessary, for example, NABWAR cases that require advice to be provided relatively quickly, but these are rare. And I was interested in Cabinet Secretary's comments in connection with the PDSO, which seems to me a confirmation of double standards in the provisions in the bill, in that PDSO will be expected to seek to collect these contributions, but in the event they don't do so, if I understood the Cabinet Secretary correctly, SLAB would then collect. So it seems to me that there's belt and braces afforded the PDSO and the provisions in the bill which are not afforded to solicitors. And on specifically the point that if SLAB were to do all these contributions, then it would impact on the savings, well, that's clearly a very distinct possibility. But equally, that shouldn't deter the government from doing what's right and ensuring that we have a justice system that is fair. I press the amendment in my name.
All right. The question is that Amendment 14 be agreed to. Are we all agreed?
Yes.
There's a division, so those in favour, please show. Those against, please show. That's 3, 4, 5 against. That amendment is not agreed. The question is that Section 19 be agreed to. Are we all agreed? Yes. Now, Cabinet Secretary, I'm aware that time is pressing, but if you could sit just a couple of minutes longer,
yes.
I can. Are we able? How long have we got? Would you say?
I think I probably need to be away by 12.
Well, we might manage to finish all the amendments in that way, because we've got a large one coming up from Graham Pearson, but the rest have all been debated. That would be very kind. Call Amendment 43 in the name of Jenny Marrow. Ready to debate Amendment 41. To move or not move, Jenny?
Moved.
The question is Amendment 43 be agreed to. Are we all agreed?
Yes.
Those in favour, please show. Those against, please show. Abstentions? 2, 4, 5 against, 1 abstention. That amendment is not agreed. Call Amendment 44 in the name of Jenny Marra. Already debate Amendment 41. Jenny, to move or not move?
Moved, Convener.
The question is Amendment 44 be agreed to. Are we all agreed?
Yes.
We're not agreed. Those in favour, please show. Those against, please show. Abstentions? 2, 4, 5 against, 1 abstention. That amendment is not agreed. I call Amendment 15 in the name of Margaret Mitchell, already debated Amendment 14. Margaret, move or not move?
Moved, Convener.
The question is Amendment 15 be agreed to. Are we all agreed?
Yes.
We are not agreed. Those in favour, please show. Those against, please show. 3, 4, 5 against. That amendment is not agreed. Call Amendment 16 in the name of Margaret Mitchell, already debated Amendment 14. Move or not move, Margaret?
Moved, Convener.
Question is that Amendment 16 be agreed to. Are we all agreed?
Yes.
We are not agreed. Those in favour, please show. Those against, please show. 3, 4, 5 against. That amendment is not agreed. Call Amendment 17 in the name of Margaret Mitchell, already debated Amendment 14. Moved or not moved?
Not moved, Convener.
Not moved. Call Amendment 18 in the name of Margaret Mitchell, already debated Amendment 14. Moved or not moved?
Not moved, Convener.
The question is that Section 20 be agreed to. Are we all agreed?
Yes.
The question is that Section 21 be agreed to. Are we all agreed?
Yes.
Is it agreed? Well, we've managing, I think. Refund of contributions. I'll call Amendment 45 in the name of Graham Pearson, group with Amendment 23. Graham, please to move Amendment 45 and speak to both amendments in the group.
Thanks, Convener. Section 45 is a standalone motion which I propose refund of contributions for legal aid assistance in certain circumstances. At the conclusion of the proceedings, a court in which those proceedings are concluded may order any contribution for criminal legal assistance due or paid by virtue of this Act to be remitted or refunded to the person from or by whom or in respect of whom the contributions were due or paid if the person has been acquitted of an offence and the court considers that it is in the interests of justice for the contributions to be refunded. Evidence to the committee at an earlier stage raised particular circumstances where currently there is no remedy offered to a citizen who, having been subject of a prosecution as set out in the motion, although left with no stain on their character, may still have to bear the cost of defending themselves against a prosecution. It's acknowledged, certainly by me and I believe by others, that there are very few cases where the court would pass criticism of the Crown in terms of a prosecution before the court. But there have been cases where judges have offered views about the nature of a prosecution and whether or not a prosecution should have been mounted in the first place. And this motion seeks to offer the opportunity to a judge in very particular circumstances, and I believe very rare circumstances, where a remedy could be offered. I understand that there may be reluctance on behalf of the government to create such a precedent, but again, going back to the notion of a fair and open society and an opportunity for a citizen to receive support from the state where the state is deemed to have gone a step too far in mounting a prosecution, such a piece of legislation would not only be helpful, but I think very healthy.
Could I ask you to move 45, please?
I so move.
Margaret Mitchell, please, to speak to Amendment 23 and other amendments in the group.
Thank you, Convener. Amendment 23 would allow for funds of contributions paid in all cases where an individual is not found guilty and seeks to address the main injustice of the Government's bill. The proposals as they currently stand mean that an innocent person taken to court will be forced to contribute to their legal aid representation if their disposable income meets the required threshold. Those who are wrongly accused of a crime and who suffer the stress and indignity of criminal proceedings will, to make matters worse, be out of pocket by the actions of the Crown. During the Stage 1 debate, the Cabinet Secretary for Justice said the bill would help to maintain a fair, consistent and generous legal aid scheme. A range of witnesses, including the Faculty of Advocates, Scottish Women's Aid, Dr Cyrus Tata from the University of Strathclyde, expressed concern about the lack of refunds in the bill. The Faculty of Advocates also argued that without a refund system, the bill would create a perverse incentive to plead guilty out of fear of the financial consequences of taking a case to trial, a view which was shared by the Church of Scotland. The Scottish Government's position on this is frankly unconvincing. I note that the Cabinet Secretary failed to address the issue during the Stage 1 debate. Instead, in his response to the committee Stage 1 report, the Cabinet Secretary said that refunds would be inappropriate because it would mean legal aid victims were treated more favourably than those who paid privately, who would, of course, not be subject to the refunds on acquittal. This argument amounts to two wrongs make a right, and more to the point, the overwhelming objective must be to ensure that the vulnerable are protected. The Government also argues that refunds would reduce the savings made under the bill. While this may well be the case, it is not a sustainable argument for introducing a system which is unfair. Rather, it is yet further evidence that the Government, having decided to cut the legal aid bill by £10 million next year and a further £10 million in 2014-15, has worked back from that to try to come up with a system to fund those savings. According to the latest custodial statistics, nearly 90% of criminal cases result in a guilty verdict. So refunds would only apply to a small minority of cases. This amendment is drafted in a way to allow for refunds of all contributions made except where an accused is found guilty. Refunds will therefore be given in all not guilty and not proven cases, as well as in other cases of acquittal, as, for example, when the Crown accepts a plea of not guilty. Turning now to Graham Pearson's Amendment 45, which similarly seeks to introduce refunds of contributions, I'm unable to support this amendment, which would only allow refunds in cases of acquittal where the court considers it is in the interests of justice for the contribution to be refunded. My concern with this is that it could send out the message that those who are refused refunds, despite being acquitted, are somehow considered guilty. Our judicial system is rightly based on the principle that individuals are innocent until proven guilty, with the burden of proof rightly lying with the Crown prosecution. Amendment 45 therefore challenges this basic tenet of Scots law. I also have concerns about how courts would determine when it is in the interests of justice to refund, and introduces subjectivity when the principle applies equally to all cases of non-guilt verdicts, in which case refunds should be given in all cases.
Yes, I'd like to say, because I was very concerned about this as well, I would look at the principle in operation here, and the principle is that in civil litigation, if you're successful, you may or may not get an award of your judicial expenses. And again, the court has discretion about how to award those expenses in the circumstances. It doesn't always mean you get all your judicial costs back. So there has to be judicial discretion. So I'm not attracted by the amendment in Margaret's name, because there's no judicial discretion there. And I think that's terribly important. And it does, to some extent, parallel what happens in civil cases. The problem for me with Graham's one is the principle in operation is if you are legally aided and doing a contribution, or if you're a private client and we apply, we want to apply fairness, then we'd have to have some system where the private paying client would be entitled to a return of some of their costs. We're really not talking about refund, we're talking about something like an award of expenses in criminal proceedings. And as Graham Pearson's amendment only deals with those on legal aid, I can't accept it because, it's all very well for pragmatic arguments. We want to work on principle here. If it's appropriate that the court considers in the interest of justice for a contribution, or in my words, it would be some kind of costs to be refunded, it must apply, surely, to people who are, and they may not be very rich, but who just happen to be above the level of contributions and are actually having to pay for their whole thing and have no legal aid cover. So that's the problem for me. And I do think it's worth the Cabinet Secretary considering this issue, but I think it's much more difficult with unintended consequences if we were to try to pass either of these amendments. That's my view on this. And I wanted to speak on this because I did feel there's an issue here about very exceptional circumstances where the sheriff takes the view, let's say, put it broadly, this never ought to be brought before me in the first case, a really narrow range of cases, because there's a whole range of other reasons why someone might be acquitted or not proven, and the evidence had to be fully tested to establish that. But somewhere, frankly, should never perhaps have been brought in the first case. So for those reasons, Margaret Mitchell, I think yours is far too broad. For your reasons, Graham, I think it doesn't do a service to those who pay privately for their defence, and we must be fair to both. Rod.
Very briefly, Convener, because you've put most of the arguments that I would have put. I've got a great deal of sympathy for Graham Pearson's amendment, but I think we've got to be fair to those who are privately paying, however small in numbers, and however few of them are acquitted. But I don't want this issue to die a death. I want it to be kept under debate.
Next, I've got any other members want to come in on that? You've got an opportunity. You want to come in now, Margaret? And Sandra?
Thank you very much. I also have a great deal of sympathy. And I did speak to Graham Pearson about this particular one, but I take on board exactly what you said, and I have discussed it regarding the private client also. But likewise as Rod, I think perhaps if the Cabinet Secretary perhaps look at this, as he has very generously said on 2 previous occasions, I think it shouldn't be left to just lie there. I think we need to kind of take it a wee bit further. That's
Margaret Mitchell.
In response to some of the comments, Convener, then I think it's important to emphasise what this amendment does is ensure that the most vulnerable are protected and, crucially, have access to justice. As simple as that. Amendment 23.
Cabinet Secretary, and then Graham, you'll wind up because you're the lead amendment.
Thank you, Convener. I think many of the points by yourself and other members have been raised. The devil is in the detail. I think the difficulty we see with Graham Pearson's amendment, what happens if the case is deserted? There's a whole variety of matters. It's not as simple as that, and where would we get to there? I can understand why the committee has, raised these concerns. They are matters I've already had informal discussions with the Crown. I think I accept the logic that you do have, Convener, that if you were to have a principle of, if you are going to have a principle, then it should apply to those who pay a fee, whether it's as a legal aid contribution or whether it's as a private client. Equally, it should also be remembered that we do have in Scotland, unlike south of the border, no concept of anybody, no matter how guilty they may be or how immoral or whatever, ever being asked for court expenses. And whether that is a corporate offence or whether it is somebody just doing a breach of the peace on a Friday night, these matters are, as I say, not added to with any court expenses. I'm happy to give an undertaking to engage with the Crown and indeed with defence agents, but it does seem to me that your logic is quite correctly that if it is to be there, it has to be across the board. Equally, if it's across the board, it might be that the law of unintended consequences in terms of what happens in terms of somebody whose case is deserted by the fiscal halfway through, as opposed to being formally found not guilty, what happens there would also be superseded by why are we giving people who have got off, perhaps on a technicality, money back and not seeking the expenses. So I'm happy to undertake. I can say that my discussions so far, the Crown do take the principle that north and south of the border are vastly different. There is no question of ever anybody being asked for expenses following a successful prosecution, but I'm happy to re-engage.
Thank you, Convener. I think I would acknowledge right from the outset that the motion was couched in the language, given the overall nature of the bill that we are considering, that it was in terms of legal aid primarily. But I do recognise the reservations raised by the Convener and by Roderick Campbell, and I'm grateful that the Cabinet Secretary is willing to give these issues further consideration. No matter the unintended consequences and so forth, I do think that if at the conclusion of a case a judge makes comments which indicates that, in his or her view, the prosecution was ill-advised and ill-considered, that we do have a responsibility to reimburse. And I acknowledge that should be whether or not legal aid is involved or privately funded. And in the event that the Cabinet Secretary is willing to take this matter forward with some energy, I'm happy to leave the motion unpressed.
You want to withdraw?
I want to withdraw.
Does anyone object? Right. So Amendment 45 is withdrawn at the moment. Call Amendment 19 in the name of Margaret Mitchell. Ready debate Amendment 41. Margaret, to move or not move?
Moved, Convener.
The question is Amendment 19 be agreed to. Are we all agreed?
Yes.
Those in favour, please show. Those against, please show. 4, 3, 5 against. The amendment is disagreed. Call Amendment 20 in the name of Margaret Mitchell. Ready debate Amendment 41. Margaret, to move or not move?
Moved, Convener.
The question is that Amendment 20 be agreed to. Are we all agreed?
Yes.
We are not agreed. Those in favour, please show. Those against, please show. 3, 4, 5 against. That amendment is disagreed. Call Amendment 22 in the name of Margaret Mitchell. Ready debated with Amendment 14. Margaret, move on. I beg your pardon. I beg your see now, I knew I would do it. You're quite right. I'm going too fast for myself. I've overtaken myself. It's not easy to do that. I call Amendment 21 in the name of Margaret Mitchell. Ready debate with Amendment 14. Margaret, move or not move?
Moved.
Right. Question is Amendment 21 be agreed to. Are we all agreed?
Yes.
We are not agreed. Those in favour, please show. Those against, please show. 3, 4, 5 against. That amendment is disagreed. Now we call Amendment 22 in the name of Margaret Mitchell.
Moved, Convener.
Thank you very much. The question is that Amendment 22 be agreed to. Are we all agreed?
Yes.
We are not agreed. Those in favour, please show. Those against, please show. 3, 4, 5 against. That amendment is disagreed. Call Amendment 23 in the name of Margaret Mitchell. Ready to debate Amendment 45. Margaret, move or not move?
Moved, Convener.
The question is that Amendment 23 be agreed to. Are we agreed?
Yes.
We're not agreed. There will be a division. Those in favour, please show. Those against, please show. 3, 4, 5 against. That is disagreed. Amendment 23. The question is that Section 22 be agreed to. Are we all agreed?
Yes.
The question is that Section 23 be agreed to. Are we all agreed?
Yes.
Call Amendment 24 in the name of Margaret Mitchell and a group in its own. Margaret, to move and speak to the amendment, and there we go.
Right, thank you, Convener. Amendment 24 would insert a review clause to Part 2 of the bill. It would require Scottish ministers to lay before Parliament a report on the operation and effect of Part 2. It is framed in such a way that the period begins on the day on which the first provisions of Part 2 come into force. This review clause will give Parliament the opportunity to consider the wider implications of the bill. Given the concerns expressed at Stage 1 and again today over the introduction of contributions and the way in which these contributions are to be collected, it does not seem unreasonable for ministers to consider this, the effect of this change. In addition to this, the significance of Part 2 should not be underestimated. It will establish the presumption that those who can afford to pay for criminal legal representation should do so. The effect of these provisions on access to justice and the efficiency of our criminal justice system could be profound. This amendment was drafted with the optimistic, but I realise unrealistic hope that my earlier amendments would be accepted. Given that this was not the case, it makes the review, I would contend, all the more necessary. Subsection 4 of the amendment states that the 3-year period begins when the first provisions of Part 2 is enacted, rather than when Part 2 is fully enacted. And perhaps the Cabinet Secretary could take this opportunity to clarify whether he envisages Part 2 being enacted simultaneously or in one block.
Could I ask you, Margaret, to move 24,
Move
please?
Amendment 24.
Thank you very much. Anyone else wish to come in on this one? Cabinet Secretary. Oh, I beg your pardon. Rod, yes.
Briefly, I think, given the ramifications, I would hope that the Cabinet Secretary, indeed Cabinet, will be taking very, very close interest in how this is developing. But whilst I don't massively disagree with Margaret Mitchell, I think the formality is something we don't really need.
Yes, can I just add from my part, Margaret, I'm very sympathetic, Margaret, to this. However, I don't think we need, my view is we don't need a formal report. The committee at any time can call and look at look at the acting of any piece of legislation and do post-legislative scrutiny. And if there are issues, I've no doubt our emails will tell us, and then we'll be able to bring forward the Cabinet Secretary to talk about anything that's happened as a result of this legislation, should it proceed in a certain form. Cabinet Secretary.
Thank you, Convener. That would echo my own views. While I understand the intention behind the amendment, I don't necessarily agree that we need a legislative requirement to do the job. There's a risk that what we consider to be the key areas of importance at this stage are not those of concern in 3 years' time. There's also difficulty in tying down a time frame. Some flexibility in the timing might be necessary, perhaps to include other developing issues which are unknown at this time, or because adjustments have been made through regulations that need to bed down. So, as we've heard, the Board continuously reviews practice and policies to ensure that the legal aid system is working as efficiently as possible. I would expect the impact of these proposals to be similarly kept under constant review and swiftly adjusted as necessary. The bill provides Scottish ministers with the ability to adjust details by regulations, and would expect that government officials will keep under review how these parts of the bill are operating. I have committed to a review of the impact of these proposals and will do so within 3 years and present the outcome of that review to Parliament. I am not of the view that the requirement needs to be enshrined in primary legislation. So on that basis, given all the other checks and balances that we have and the assurance of what I intend to do, I would suggest that it's unnecessary, although, as with yourself, I agree where Margaret Mitchell is coming from.
Thank you, Convener. Given the unwillingness, indeed refusal, to accept any of the amendments which would have provided the checks and balances to which the Cabinet Secretary refers, then I consider it all the more important that this review is carried out, and I therefore move Amendment 24.
You're pressing it.
In my name, I
You're
press
pressing
it.
it. Thank you very much. The question is that Amendment 24 be agreed to. Are we all agreed?
Yes.
We're not agreed. Those in favour, please show. Those against, please show. 3, 4, 5 against. That amendment is disagreed. The question is that sections 24 and 26 be agreed to. Sorry, I beg your pardon. Sections 24 to 26 be agreed to. Are we all agreed?
Yes.
The question is that the long title be agreed to. Are we all agreed?
Yes.
That ends stage 2 consideration of the bill. Can I thank the Cabinet Secretary for staying on, and can I thank the committee for being so good, even though I was trying to go more quickly than usual and making mistakes. We'll have a little break till 12 o'clock to allow the screen to go up. We're going to private session now.